para la tarde de hoy. A continuación intervendrá el doctor Christopher Cole con la conferencia No tan fácil como se anuncia, nuevos retos en tener un caso exitoso de publicidad engañosa.
Buenas tardes, estimados colegas. Es un honor para mí dar esta plática y estoy ansioso a aprender de los otros presentadores y participantes de la conferencia sobre los temas de protección al consumidor de interés común. I'm challenging the translators. En los Estados Unidos estamos empezando los ojos a problemas internacionales de protección al consumidor. No solo estamos viendo un aumento de cooperación en la aplicación transfronteriza, es a tough one, sino que además muchos de nuestros clientes de Estados Unidos operan en todo el mundo. Bueno, eso es todo el español que puedo manejar. Estoy seguro que sentirán alivio cuando comience a hablar inglés. So to continue then, why did I think they asked me here? I specialize in private advertising litigation. And in the United States, that has emerged as a powerful mechanism for ensuring consumer protection. Self-policing, if you will, one company suing another one over false claims. Well, we don't need that, because I have the lavalier. So why should advertisers in the United States look, for example, to what's happening in Colombia, or Peru, or Argentina, or Bolivia, and why should those countries be looking at us? Well, I can think of two reasons. One, our corporations are increasingly operating across borders internationally. We are selling products over the internet, outside of our borders, and consumers are purchasing products from other countries. So that's one reason, that's an obvious reason, without regard to national boundaries. The US and Canada, for example, are each other's largest trading partners, with hundreds of billions of dollars of annual trade. The US trades more with Mexico and Canada than with China, for example. Now the FTC and the competition bureaus of Mexico and Canada and others regularly communicate, and you're going to hear more about that. They bring joint enforcement efforts. And almost all of my own clients' anticipated growth in the United States is flat. And they look to markets overseas for their biggest growth potential, both South America and Central America, as well as the Far East. Those represent major growth opportunities, but by and large, US companies don't understand the legal systems very well and need help. And the economies of those countries are growing much more rapidly. Colombia's GDP growth, as last I checked, is twice the growth rate of the United States. So most major consumer products companies see huge growth potential in your markets. Reason number two, harmonization is good for business and it's good for consumers as well. Most nations can agree on the basic principles of consumer protection. False advertising, bad. But they may differ on the means, the precise means of accomplishing those goals and the way they implement their regulations regarding consumer protection. Harmonizing regulations can help reduce transaction costs for business, increase predictability, while achieving the same important goals of protecting consumers. So I'm frequently asked, for example, by major US companies who want to run the same kinds of ads overseas to help evaluate the risks. And I can evaluate it on a basic level, and we have an office in the EU, for example, in Brussels that helps do that as well. But we have to frequently reach out to counsel in the respective countries to understand the particular ways that those laws are implemented in these countries. But many campaigns and claims are used across the world. For example, I represent Schick. They make razor blades. They use the same ads in the EU, they use the same ads in Australia. Obviously the language has changed, but the same basic claims, and you heard about Benoit talking about substantiation. That fundamental science, the fundamental way they do claims, they do it once, and then they interpret those ads and run them in other countries. So the conference organizers, I think, have been very smart to organize a conference where you're sharing ideas internationally, trying to share best practices and to understand how every country implements its false advertising consumer protection laws. For businesses, it's important to understand that a campaign they may have to defend in the US, they may ultimately have to defend in Germany or Argentina or Australia without regard to any formal conflict of law analysis or jurisdictional analysis. So, what I'm going to do is talk a little bit about the United States, how the private advertising litigation system works in the US. I'm going to walk through the law, which is I think, somewhat unique. I was learning a little bit about Colombia legal system today. So let's see if I can work this. I thought I'd walk over here, by the way. I feel sorry for the people over on this side of the room, because they have to look through the column all the time. So this is a famous quote from a UK comedian. But I think it holds true, and it represents what people think of advertising in general. Consumers are suspicious. They think that advertisers are trying to mislead them, and that in order to sell a product, they have to arrest the human intelligence. The regulators in the United States, and this is a gross oversimplification, we have three primary ones for general advertising matters. The Federal Trade Commission, you heard Leslie Fair speak at length about that. And then in the US system, we have a system of federalism. We have 50 different states, each with their own government, and state attorneys general. And all those attorneys general implement a law similar to the federal government, an FTC Act of their own. They call them little FTC Acts. And they can bring their own lawsuits relating to advertising within the borders of that state. And frequently they get together and sue as a group. So you might see 18 or 20 state attorneys general bring a case against a major advertiser. Then you have the NAD, and I won't talk a lot about NAD. National Advertising Division is a self-regulatory system set up by the advertising industry itself, and they hear advertising challenges every day as part of their mandate. They have a staff of full-time attorneys. They're based in New York City, and it's a very effective system for companies to bring challenges against one another relating to advertising claims. And then the one that I am going to talk about a lot is the federal courts and something called the Lanham Act. The Lanham Act is basically the same law that regulates the trademarks. It's the trademark statute, but it also has a false advertising provision. So what are the remedies for false advertising? If you represent a company, or you're a company and you're upset about a competitor's false claims, you can complain to the Federal Trade Commission. Sometimes that works. The Federal Trade Commission will generally take up complaints that that involve real consumer harm, real consumer fraud. But often, I mean, you think about two companies selling chocolate bars, and one says, my chocolate bar tastes better than the other chocolate bar. That's not the kind of complaint that the FTC is particularly interested in hearing, because they think these two companies can fight it out themselves. You don't need the government to step in and help you resolve that dispute. So, another alternative is the National Advertising Division. The third alternative is a federal court lawsuit, which is quite popular, and we'll talk about that. And then the fourth, a growing problem, if you will, is consumer class actions. And I understand you have a consumer class action. You bring a lot of consumer class actions here in Colombia, but perhaps not so many about false advertising, but maybe other issues like environmental issues. But in the United States, class actions on false advertising are extremely, extremely common. And all of these three things, they all work together. So what we're seeing now is one after the other. So you may see the Federal Trade Commission bring an enforcement action and render an order, and then as soon as the order is made public, plaintiffs will file a lawsuit, perhaps in California or multiple states, on the exact same facts and seeking redress for a class of identified consumers. And so there's duplicative and higher risks for companies in the US. It's a big problem, and it actually threatens to undermine the National Advertising Division in particular, because the National Advertising Division is a self-regulatory forum with no independent enforcement authority, no ability to fine. It's a voluntary process, but they do publish their decisions. And the plaintiffs' lawyers see the decisions coming out from the National Advertising Division, and then they sue based on that decision. That disincentivizes companies from participating in the voluntary process, and in the long run, it may undermine willingness of companies to participate in self-regulation. Section 43A, we talked about NAD. Section 43A of the Lanham Act is primarily directed at providing competitors with the right to sue. It is not a law that consumers can use, only competitors. The remedies for this law include an injunction. That's the most powerful remedy. And that's why a lot of these cases begin on an emergency basis with an application for what we call a temporary restraining order or a preliminary injunction to stop the advertising before a trial, a full trial, can be held on the merits. The idea behind that, I'm sure you have similar processes in your own courts, is to preserve the status quo pending a decision, a final decision on the merits. Very powerful remedy, and it acts nationwide. If you get it in a federal court in the United States, it will operate nationwide. So no other remedy that you can get has the same force and effect. You can also, and I'll talk about these a little bit later, get disgorgement of profits, damages for lost sales, corrective advertising, and damages and attorney's fees. And these can all be trebled under the law. If the claim was willfully false or egregious, you can get very severe remedies. The highest one that I'm aware of under the Lanham Act recently began as an antitrust case between two companies that were selling surgical syringes to hospitals in Texas. The jury rejected the antitrust claims but found against the defendant on false advertising and awarded $113 million in damages. Just one case. So why do we have a Lanham Act? I think the history is a little, is informative. And it may, especially for a country like Colombia, where I understand that competitors can sue for injury caused by false advertising, but perhaps there's not a special statute like the Lanham Act here. And the reason the Lanham Act was created was that the common law, which the US operates under, did not deal with competitor false advertising cases very well. You had to prove, essentially, that a specific ad caused you a specific level, quantifiable level of injury. Very difficult thing to do for anybody who deals with advertising cases, to point to specific lost sales that are caused by one ad. So if you had a market with multiple participants, for example, let's think about telecommunications, 5 different wireless service providers, and one of them advertised that we had the fewest drop calls. That's a claim that Benoit talked about. How do you prove whether, if you're one of those other 4, that you were injured as opposed to the sales coming from all the other 3, particularly in complex markets? So the problem, the common law could really only deal with a two-company market or a two-company category. Common law also frowned on sort of on what they called the vicarious avenger, meaning somebody who raised the flag on behalf of somebody else in order for the common good. That just isn't something that was recognized under the common law. So there was a problem, and Congress enacted this section, 43A of the Lanham Act, and as I said, it also deals with, this law also deals with trademark, and trademark's a little different than false advertising, although it does serve similar goals. In trademark law, what we're concerned about is ensuring that consumers who see that mark understand that they're getting the real product, because the company that has obtained the mark and has built up goodwill and trust within that mark, consumers can see that and understand the significance of that and know that they're getting a certain quality of product. And so there's an economic justification if you allowed everybody to infringe each other's trademarks, and nobody would know when they're getting the quote, real McCoy, as we call it in the US. Well, false advertising is a little bit the same. False advertising disrupts markets. It disrupts the proper functioning of markets. As a company that develops a claim, I like to view advertising claims, a well-substantiated, supported advertising claim is like an asset of the company. And if other companies are allowed to say they do the same thing but have never proven to do it, or they're allowed to say they do it better and don't have proof for that, they've undermined the value of that asset and disincentivized the company from investing in the development of that kind of asset and ultimately in improving products and experiences for consumers in the long run. And for consumers, on the consumer side, when you're trying to choose among products, obviously you would be injured if you're acting on false information. So the Lanham Act was very much understood as a law that would enable the free flow of truthful information. It's only concerned with truth or falsity of advertising. And several of the people in the first session talked about how important the free flow of truthful information is to commerce, and how advertising is part of the input to the creation of the product itself. And as somebody that enjoys working with, and I know Benoit does this too, working with companies from the very inception of the advertising campaign, you realize how much work goes into development of the claim, and how a successful claims process drives product improvement on a continual basis. So truthful advertising is part of protecting truthful advertising is part of protecting the engine of product innovation. So here are the key terms. Any person who are in connection with any goods, and I'm going to break these down a little bit more, but they're talking about false or misleading descriptions of fact, and then in commercial advertising or promotion. And it can involve your products or another's products. Now compare this to the FTC, which, as Leslie showed, it regulates deceptive and unfair trade practices. There's no unfairness aspect to the Lanham Act. So the Lanham Act is not concerned about cost-benefit analysis. The Lanham Act is simply concerned with the deceptive prong. But there's an important distinction between the FTC's jurisdiction and the way it enforces it in the Lanham Act. I'll get to that. Let me go back, actually. The FTC, they have two fundamental differences in the way the advertiser has the burden of proving its claims true. That's called the prior substantiation doctrine. And as a policy, the government has said we want advertisers to have evidence in their file before they run the ad that the ad is true, competent and reliable scientific evidence. That is an important policy judgment by the FTC. Now, under the Lanham Act, if I sued a company and my allegation was this company does not have evidence to support its claim, it did not do testing prior to the trial, I would lose. I have to prove, it's my burden under the Lanham Act to prove the claim false. It's not enough for me to say they don't have enough evidence, except in a very narrow category, which is relevant here. So who can sue? This is a subject that was a very recent Supreme Court decision. I've told you that consumers can't sue, but there's been some debate about how remote the injury must be in order to bring a case. You have to be an injured party, clearly, under the statute itself, but the courts over the years have been developing what they call prudential standing limitations. Under US law, we have three columns of the government. We have the executive function, we have the courts, and we have the legislative branch. And Article 3 governs the courts, and the courts are not allowed to make law. The courts are only allowed to decide cases on facts, live disputes before them. If they render hypothetical decisions, that is lawmaking, that infringes on the legislative turf. So we call that doctrine standing, and I'm sure there's analogs in many of the laws. But perhaps it's best to explain what the case was about. Under computer printers, they make their money by selling the ink. Everybody knows they sell the printer for very little money, and then the ink is where they make all their money. So there's a vibrant market now for resellers of refilled ink cartridges. So you could buy your printer from HP, and then HP sells ink, but a lot of people will take those used cartridges and refill them. So HP got smart, and they put a chip that said once the cartridge was exhausted, you could not reuse it and use all the functionality in your HP printer. So Static Control made a little replacement chip that could fool the printer, essentially, in refilled cartridges in order to enable the cartridge to work. It's legal. I mean, you cannot control the resale of your products. HP did what it did under the law correctly, and Static Control was operating under the law correctly as well. Well, HP, or not, actually it was Lexmark, a similar original manufacturer, sued to say that static control was, they ran a campaign saying that anybody who uses static control parts is violating the law. Static control counterclaim for false advertising, saying that's a false ad. And the court grappled with the issue of static control is not directly competing in the print market, it's just selling a little downstream component, a little chip. So do they have standing to sue? And the Supreme Court said yes. So in general, what it says is that the decision says that as long as you can trace your injury, reputational or economic, to the false advertising, then you have the right. Consumers' injuries are too remote. There's too many intervening causal factors. So, but you don't have to be a direct competitor. You could be outside of that zone as well. Here are the elements of proof. The key ones I want to talk about, and I'll walk you through some examples. False or misleading statement, a fact. Actual deception or tendency to deceive. There's a lore about that. The deception is material insofar as it has to be something that consumers would rely on. That's important. Interstate commerce, the law only deals with goods and services that flow across state borders, not solely within one state. And then injury. False or misleading statement. Could be about your own product, or could be about the competitor's product. Statements, this is an important limitation, have to be made in advertising. There are a lot of cases about one salesman who goes up to an account and tries to sell a product and says something false. Is that one statement an advertisement? The courts, by and large, have said no. It has to be systematic, broad-based campaign. And these cases get litigated on this issue all the time. But the cases that are close calls usually involve one-on-one sales calls, or perhaps an email. I was involved in a case in the very sexy world of prison food advertising. And somebody from our client sent an email saying that the beef sold by their competitor had been recalled, but it was being sold in prisons anyway. And it was a rogue employee, but he sent it to all the accounts at the same time. So that was a very close call as to whether that, now we ended up settling the case, but you can see how a rogue employee could be held to be the advertising of a company, then you could really broaden the liability. Now, only statements of fact. I understand there's going to be a panel later on puffery. I'm going to give you a couple of examples under the Lanham Act. Only statements of fact are actual, not opinion. We think we're the best, or I'll show you and I'll illustrate that. Here's the seminal case on puffery. You want to run the first one, Papa John?
Pizza Hut dares anyone to find a better pizza.
Oh, really?
It was a challenge Papa John couldn't resist. So he commissioned independent taste tests, and Papa John's won. Won big time. Maybe that's because Papa John's sauce is made with fresh-packed, vine-ripened tomatoes. Pizza Hut uses remanufactured paste.
Anybody can claim to make a better pizza, but it's you, the consumer, who decided. Better ingredients, better pizza, Papa John's.
Do you have Papa John's in Columbia? So do they use the same slogan, better ingredients, better pizza? So that slogan, the issue was, does that slogan mean that we have better ingredients and therefore our pizza is better? In other words, tastes better? Well, the court issued a split decision, and that ad illustrates why. Puffery has to be determined in context. The court said, standing alone, the statement better ingredients, better pizza simply means, it's a truism. It means our ingredients are better, we're likely to have better pizza. It's something that's unprovable, it's immeasurable. However, in that particular commercial where they showed the split screen, on one side there was the fresh tomatoes, and the other side was this awful tomato paste, the court said there you are using it in the context of a specific representation about the kind of ingredients you use, and they also reference a taste test in there. So the court said that they did not have enough evidence to support that claim and enjoined that aspect, but the logo or the slogan lives on. Let me show you another example. Kimberly Clark. This was my case. Can you run that one? This is a kind of a funny ad.
If your baby happens to be other diapers are the perfect shape. New Huggies Natural Fit are shaped for babies of the human variety. They're less bulky than before and designed to fit more naturally. Huggies Natural Fit.
So that ad campaign was called, affectionately, Brick Baby. And I represented Kimberly Clark, and you can imagine Kimberly Clark makes Huggies. They were the sponsor of the ad. Procter & Gamble makes Pampers, and they weren't very happy. So they sued, and both parties had studies on what was a better fit for babies. They actually had hundreds of mothers bring their babies in, and they measured the babies in the way that the diapers fit. Both sides presented evidence about this in court. And sort of a secondary argument, as you often do when you're a litigator, is throw in an argument, and we said, well, it's also puffery, because who really knows what a better fit is? And the judge bought that argument. He liked it. And he said, well, frankly, you cannot ask a baby what diaper fits them better, so that's puffery in my view. And he refused to issue the injunction based on that. So it goes to show, it's a questionable decision, although we were very happy with it, but it goes to show that these decisions are made by the fact finder in the front end, and very often by a federal judge who brings their own preconceived notions. So how do you evaluate the messages in the ads? We have a sort of a well-defined way of thinking about it in the US. Literally, we divide the world into literally false or express claims and implied claims. A literal claim is a claim that is capable of no other interpretation. It's clear on its face, and the only reasonable interpretation is the one that you're litigating. A judge can look at that claim on his or her own and issue an injunction without regard to any other evidence of consumer interpretation. However, for an implied claim, the burden is on the plaintiff, in this case, to produce what we call extrinsic evidence of consumer interpretation. Now, in a case where you had very few purchasers, a small market perhaps, with a few buyers, you could bring in your buyers to testify. I saw the ad, I thought it meant this, and I was shocked to find out it didn't mean that, and therefore that would be evidence of an implied message. But typically the way you do it for large consumer products cases is to do a consumer survey, the kind of stuff that Benoit's group does, where you actually show the ad to 400 people nationally, and you ask them what you think it means. And there's a big body of law that's built up around whether those consumer surveys are admissible or not. A consumer survey, doctrinally, is really just a way of admitting hearsay. Because what you're trying to do is admit the opinions of 400 random consumers out there in the world without having to bring them into court to actually to hear all 400 people testify. So what you do is you have an expert, usually a professor of marketing or consumer behavior, who does it in a systematic way and then can synthesize that and present the information in a summary way so that the judge and the fact finder can hear it, and that is recognized as an exception to the hearsay rule. The general standard, consumer surveys have to be done like experiments. So in a typical survey, I would show the true ad to consumers, and then I would show another version to another set of consumers that takes out the false claim or the objectionable material, and then I would compare the two. Because what you're trying to do is filter out prior beliefs. A lot of people harbor prior thoughts about whether one product tastes better or not. You want it to hone in on what the ad itself is communicating. And then the judges have created a rule, and I'm not even sure where this comes from, but it's built up over the years, that you have to have a net of control to test ad at 15%. In other words, we're going to accept that 15% of people who see the ad may be misled, and we're not going to issue an injunction if it's 15% or less. And then some courts say 7%, some courts say 20%. That's just the acceptable level of noise. Because if I show an ad, if I showed that Kimberly-Clark ad to 200 random United States consumers, you're going to have some people who think, I don't know, it's about puppies. I mean, honestly, people say the strangest things. The FTC analysis, again, is different. So the FTC does not need to prove consumer takeaway. The FTC is an expert agency and can assert that an implied claim has been made based on its own expert opinion. The courts have upheld that time and time again. And as a defendant, usually representing defendants in front of the FTC, I think they should have to prove that, but the courts disagree with me, so that's the rule. In practice, the FTC often does introduce consumer survey evidence too. Let me show you, claims can be visual too. Let's run this one. Oh, I lost my, can you do that, Diego? This is another campaign that we dealt with. We represented AT&T and their big competitor Comcast in the US.
We got AT&T, look what we got. I thought technology was supposed to get smaller, not bigger. Look at it, taunting us. Oh.
Once you see AT&T, you'll want it to go away. A network with less HD, slower internet, and a big box. What else did you expect from a big old phone company? Stick with Comcast, the proven advanced technology.
You get the sense that Comcast really likes AT&T, don't they? So AT&T sells a cable product too. It's not only a telecommunications company, but it sells TV service through a product called Uverse. And Uverse, in order to install Uverse, they run fiber optic cables to all the neighborhoods. And they have to install these big boxes that you saw there in each neighborhood that they serve. And it was very controversial. People didn't like these boxes in their neighborhoods. They're ugly, they're big. And they fought town by town, literally, to get the authority to install these boxes. And Comcast knew that, and they were trying to scare people and get them to go to the legislature and complain about AT&T installing this so that they wouldn't have to deal with this competitor. And the ad, we argued, and the judge agreed, that the ad clearly implied Uverse, you would get one of these boxes, not just in your neighborhood, but right in your front lawn. And the judge agreed. We didn't have to submit consumer survey evidence on that, but that was clearly a false claim. Whoops. All right, we actually talked about that. So let me talk about how significant the law can be in practice. Dyson, you probably all have heard of Dyson at this point. In 2007, Dyson entered the United States market. Hoover was the main company in the US. Within 1 year, Dyson was the #1 selling vacuum cleaner in the United States. Hoover was destroyed within 3 years. The company ultimately was sold in 2009 to a Chinese company for a total of something like $17 million. It was just a bundle of liabilities and some trademarks. They had no value left in the company, a bunch of debt. And Dyson was really kind of responsible for it in many ways, because Hoover really didn't keep up with the times. Dyson had a very unique insight to sell vacuum cleaners in a way that had never been sold before. One, they look cool, right? They're beautiful vacuum cleaners, and people use, the old style vacuum cleaner was what your grandmother used. It was just sort of an ugly thing you put in the closet. So the Dyson vacuum cleaners, the design was very much part of it, something that you would not feel ashamed to leave outside even. But the other thing was the claim of no loss of suction. He is a brilliant man, and he, after many years of trying, developed a cyclone system that prevented vacuums from clogging the more they fill with dirt and dust. And they had no bags like the old style vacuum cleaners. And he tapped into a frustration that many people had had with vacuum cleaners, that they would fill and they would lose suction over time. So his main claim that he went in hard with, they had very stark, very great advertising. Since the vacuum was first invented, it had a basic design flaw. Bags and filters clog with dust and then lose suction. And then he talks about the cyclone. So nothing clogs, and it doesn't lose suction ever. So how did this claim get challenged? Well, Hoover said two things. One is, it does lose suction eventually. Even though it doesn't have a traditional filter, even the cyclones, there's a small filter at the end that you have to rinse every 6 months. And that would clog if you didn't remove it. So that's one argument. The other argument they said was people hear it doesn't lose suction, but what they think is picks up dirt better. And that's not a claim that Dyson could actually substantiate. Dyson could substantiate that it never lost suction, and it did so this way. These are the 3 original models of the Dyson. These are all the other brands on the market. So this is a claim, this is a test. You heard about the ASTM. There's an analog in Europe called the IEC, International Electrotechnical Commission. A group of scientists get together to publish standards of testing. This one is dust loading over time. So you take the vacuum cleaners and you feed a certain kind of dust in slowly under controlled conditions, and then you measure their suction with a special apparatus. And you can see all these other brands, the suction would just decrease. The Dysons went like just flat. The problem is that's a one-time test. So you do it once, you load in, I don't know, was it 50 grams of dust, and then you stop the test. How many more times should you have to do that test to ensure yourself that it never loses suction? And so that was what the case was all about. And both parties in that case had excellent testing evidence, but both parties had to argue with the judge over the weight of the evidence. And in the US, the judge can be the fact finder, but you can also bring these cases in front of a jury. So the juries can only determine facts. They cannot determine law. So the judge applies the law, but the jury can issue a decision on fact. And so you have to argue this technical evidence, and it can be quite complicated to a group of 12 people, some of whom maybe not graduated high school. The case was settled, by the way. Dyson still uses that claim. Materiality. Why do we have a materiality? The law, we don't want the law to be misused for claims that don't mean anything. So we require the claim that's being challenged to have some influence over consumer purchasing behavior. And this is an emerging area of the law, really, because it used to be all sorts of presumptions would apply. If you could prove that an express claim was false, the courts would generally presume materiality. That's no more. That presumption has gone away. But certain claims still enjoy a presumption. For example, claims about price or claims about a central characteristic or feature of the product are generally going to be considered material. But it is the case now that companies are submitting evidence of materiality. And the way you can do that is by a conjoint analysis. You could show consumers an ad for the product with a feature, and then you could show consumers an ad without the feature, and then ask them how much they would pay, depending on the product with the feature or product without the feature, and compare. So you can separate out in that way the value of the advertising to the product. And then injury. How do we show injury? I'm going to go into this in a little bit, but for an injunction, you have to show that the injury cannot be remedied just with money. And that's kind of a fascinating doctrine under US and common law. To get an injunction, it has to be irreparable injury, not compensable through money. And that's typically injury to goodwill, reputation, and often market share as well. So they asked me, I wrote a paper about this a few months ago, and Diego said it'd be interesting to talk about that. The presumptions of harm no longer exist now that we have to prove harm. And there was a famous Supreme Court case called eBay versus Merck Exchange. It was a patent case where they had proved infringement, and the court presumed injury and granted the injunction. The Supreme Court said, no, you cannot any longer presume injury. Even in a patent infringement context, you have to show actual harm of a kind that is irreparable. Irreparable harm still can be presumed in there's a split still in the circuits, but in the Second Circuit, which is New York and the surrounding states, you still can get a presumption of irreparable harm in a small market, a two-firm market. That would be probably an exception that would enjoy acceptance in other jurisdictions. So what does eBay mean practically? A court could find that an ad was false and yet allow it to continue in the United States. I mean, that's the basic thing. Consumer harm is not really part of this calculus. If If irreparable injury is not demonstrated, the court may not issue an injunction under U.S. law, and that's harm to competitive interests, not to consumer interests. Now, I have yet to see a case that comes out this starkly, but that is really what it means, that as a court, if I'm convinced that the plaintiff could be compensated with money, I might let that ad run, despite the fact that it continues to deceive consumers. Now, I mentioned before there's consumer class action risk, so I think that if a decision were published like this, you would see the next day 5, 6, 7 consumer class actions filed for consumers asking for money back. So the law, as I said, has been pretty popular, and this is, I haven't updated this since 2012, but this sort of shows two things. One, it shows there's quite a few cases. So in the peak, in 2005, there were 140 decisions rendered. These are published decisions. They're not an analysis of every case filing. That primarily involve false advertising. Very often a false advertising case is brought together with a patent case or with some other case. These were ones that were solely false advertising cases. So 140 cases nationwide in the United States in 2005. And then what you see, kind of interestingly, the economy does badly. And you probably see a little bit of a lag. These are published decisions. So when the economy goes bad, people stop bringing these cases. And then these are the preliminary injunctions granted, and then preliminary injunctions denied. That has varied up and down, but what we looked at in our article was after this eBay versus Merck exchange, were the number of injunctions going down. And in fact, we have seen that. So courts are less likely to enjoin these cases, at least on a preliminary injunction basis. The counterpart to that, though, is that more of these cases are going all the way. So it used to be you would bring your preliminary injunction action, you'd get quick result from the court would enjoin the ad or not, and then you would settle. Both parties would go their own way. Now what you're seeing is companies going the distance like the case in Texas, the $113 million case. So we're seeing more cases with more money damages happening these days than we ever did before. This is an evaluation of NAD case reports. So the NAD actually is very remarkably consistent with the trends we see in the Lanham Act cases getting filed. So these are private challenges in the sort of an arbitration self-regulation form. You see a spike around, I'm sorry for this axis, but around 2005, and then a sort of a downward trend. If I did this and took it out to 2014, we do see an uptick again. Many more cases have been filed in the last, this has been a very, very busy year for us. It goes with the economy. It's a little bit like patent litigation in that way. This is sort of discretionary litigation. It's not life or death. And companies bring it when they have the money to bring it. These are other subsets. These are, NAD brings self-monitoring cases, so they act a little bit like the FTC. They bring their own cases on their own accord. When they get less busy on other cases, they bring more of their own cases, as you see. The other thing you've seen with the NAD is the stakes have gone up. The NAD has a process for compliance actions where if a company, the NAD renders a decision and the company refuses to comply, the challenger can bring a compliance case. And what we've seen is increasing rates of non-compliance with the NAD. That's potentially a problem. The NAD will refer those cases to the Federal Trade Commission for enforcement. You'll hear more about that later, so I won't go into it. But we see a lot of companies sort of digging in their heels and saying, I'm not going to comply. Talk a little bit about damages to illustrate how powerful the law can be and how difficult it can be to show. You can get lost profits on sales that are actually diverted. You can prove that are sales that are actually diverted. Tough to do in a complex market. Lost profits on sales you had to sell. Let's say you did a fire sale because your product is no longer doing well, and you did a fire sale, so you could sue for that. Sometimes they abandon the product line and totally that you could get that. Injury to goodwill and reputation, corrective advertising, costs of defendants' false advertising. That's one proxy the courts have sometimes used, is how much money did the defendant spend on the false claims, and we'll assess that as damages. Attorney's fees and traveling. Let me just quickly go through this since I'm running out of time. I like this. This is for you, Benoit. In ancient times, they had no statistics, so they had to fall back on lies. It's very difficult. I mentioned how difficult it is to show. If you assume, how do you get evidence that your product sales have changed as a result of the advertising? It's very difficult in complex markets to show that one factor solely. Advertisers struggle with this all the time. Ad agencies struggle to measure efficacy of ad campaigns. So you can look at sales, and then let's assume the ad campaign began here. You might see, this is actual data from the case, an uptick. That would be the ideal case, right? You could show this delta here. There's other proxies, however. Companies are surveying all the time awareness of their brand, of their product. So you use other things like top-of-mind awareness. That one you would see perhaps go up as well. Or that's top-of-mind awareness is the sort of the first thing that comes to mind. And then there's unaided brand awareness. In other words, how familiar are you with a brand without any prompting or any stimulus? But it's difficult in certain cases to show because, for example, if there's a new entrant, you're going to assume they're going to start to sell products in an increasing level irrespective of their advertising. Or they may have advertising that just informs people about the product itself. So you have to separate out how much of this trend line is caused by the advertising, the false claim, as opposed to just the fact that it's there. And you can do that sometimes by understanding what other companies in the industry had done. And you might see some, for example, there's a hypothetical situation. A new entrant in year one doesn't sell so much, but steadily rising, and then you start to see an impact on incumbents. Well, that's all I have to talk about. I'm out of time. I'm at zeros. But I hope I had a chance to meet everybody over the break and over drinks or something. So thanks.